Hello, hello, hello. Good afternoon, everyone. I hope you guys are doing great. Thank you for joining me. I see that some people have joined already. Quiet Storm, how are you? All right, guys. I have some really great updates to give you guys, some not so great. And I want to also talk about certain things that we need to be doing right now. So let me introduce myself for people who are just tuning in for the first time. My name is Ifama Odunlami. I'm an immigration attorney from the Odunlami law firm. Our office is in New Jersey, but we serve clients in all 50 states. And thank you guys for joining. And please say hello when you come in. And if this is your first time joining, please let me know this is your first time so I can give you a shout out. All right, so I'm on Facebook, I'm on Instagram, I'm on YouTube, and I'm on TikTok. So I'm just gonna go over a few things, and I'll make some time to answer a few questions. Remember, uh, these questions are just for my responses are for informational purposes only. I'm not giving legal advice; it's information. So let's get started, okay? So unless you have been living under a rock, we know that we are in crazy times, especially not just for immigration, not just for immigrants, but really it's just crazy times in America. There's a lot of changes, but I'm here to talk about the changes and how they affect our fellow immigrants. So uh, I'm just going to do some recap of some of the news. I'm going to do a recap of some of the news that we have gotten recently, and I want to go into some things that I really wanted to tell you guys. I always tell you guys knowledge is power. It's your duty to stay informed. And it's your duty to stay informed in this atmosphere because there's a lot of fake news going on. There are people who are spreading rumors, spreading lies, just and I think they get some kind of perverse thrill in making people anxious and afraid. And are people anxious and afraid? Yes, they are. It's just a really horrible situation because the new administration really, really made good on its promise to target immigrants as the root cause of all their problems. So, as a result of that, we've gotten a lot of executive orders and a lot of changes in policy. And it's important for you guys to know that. Thank you, Michael. Thank you for joining. This is your first time. So I want to talk about, give you updates on some of the rules, some of the breaking news that came out in the past week or so. So let's start by the news that came from, I think it was Washington State, where a federal judge basically blocked the ICE raids in certain houses of worship. So there was a lawsuit filed by certain religious institutions, the Quakers, I think some Baptist churches, and some Sikhs. They basically filed a lawsuit arguing that the ICE raids in sensitive areas such as churches, religious places of worship, hospitals, schools, violated the First Amendment's right of religion, of congregation. And this judge agreed with them, but he limited his ruling to just the people that filed the lawsuit. So basically, what I'm saying is churches, mosques, places of worship, hospitals, schools, all of these places are still a fair game for ICE. ICE is conducting raids in these places. So you want to know this so that you can, protect yourself accordingly. Well, welcome, Joseph. Thank you for joining. Now, let's talk about a new rule that basically says it's a new policy that if you're out of status when your case is denied, you will be put in deportation proceedings. And I'm going to break this down for you guys. So basically, what this is, I'll give you an example. You come here in a B1, B2, you overstay. You get married to a US citizen, they file for you, your case is denied. Now, you will be put in removal proceedings. That's the new policy, right? In the past, they would just deny your case and not refer you to deportation proceedings. They would just leave you unless there was some fraud indications, or unless for some reason they wanted to refer your case. But most of the time, denials were not, in certain categories, were not referred to immigration proceedings. But now there's a new policy that has changed. So it also goes to people who file a case and withdraw that case. So you file a marriage case, you withdraw it maybe before the interview. The withdrawing of the case does not prevent you from being put in removal proceedings. So you want to know that, right? So you want to be very careful when you're filing the case. You want to be very careful when you're withdrawing the case. Now, another thing I want to talk about are spouses who withdraw their cases when they're mad at their significant others. There's a lot of consequence to your significant other. If you withdraw your case and then you change your mind and want to continue, you can't do that. You cannot unring that bell. Once you've withdrawn the case, that case is considered withdrawn. And the case that is considered withdrawn can put that person in deportation proceedings. And of course, if you're in deportation proceeding, does that mean you're not going to get a green card? No, it doesn't mean that, but it means that it's going to become more complex. You're likely going to spend more money. So when you pursue an action, just make sure that you understand all the ramifications, okay? Now, that's why it's really important that before you file a case, you want to make sure that you and your lawyer discuss, the requirements of the case, because back in the day, people would just file a petition just to get a work permit. You cannot do that, because whether you're denied or whether you withdraw your case, there are consequences. So all those people who go to notarials just to file cases that they're not even sure what was filed for them, this is not the time to do it anymore. I mean, there was never a time to do it, but people did it because I guess maybe there was no consequence to it. Now there is. So basically what I'm saying is you want to understand what you're doing before you do it, okay? It's a great idea to talk to a reputable attorney, not those attorneys that'll file any lawsuit, any case just to file it. You want to make sure you're talking to somebody. You want to make sure that you're understanding what is being filed for you. So I want to go over, once I'm done with some of this news highlights, I want to go over some pathways that a lot of people are not aware of, okay? Now, let's talk about this new, the news that came up last week. It was a breaking news about alien registration. Now, this is huge. The government is now requiring people to register. If you're over the age of 14 and you're going to be here in the United States for longer than 30 days, you have to register. If you're under the age of 14, your parents have to register you. And they have to register you within 30 days. Once you're over the age of 14, you have to register yourself, even though you were registered before. Now, the good news is this: if you've had any contact with immigration, either you've applied for a B1, B2, or L1, or you've had biometrics, or you came through the border and you were put in proceedings, or your F1, you're already registered, right? So they're really looking for a certain group of people. They're looking for people who came from Canada, but were not, they don't have any proof that they came through. They're looking for people who came in through the border and were not paroled in. And there's a third one, I forget what they're looking for. Let me see if I can, because I did a video on that. So let's see what that is. So for most of you who are here, you're likely not going to need to get registered again. But the important thing I want to add is that there has not been any processes put forward with regards to how the registration is going to go. So there's really nothing to do now until we get more information about that. So let's see. I'm trying to look for where I had those notes on the requirements. So hang on. It's hang on. Let me get my notes. All right. So it's Canadian visitors who enter the land ports. So if you're a Canadian visitor coming through land without registration evidence, they want you to get registered. If you're an individual who's present in the United States without inspection, admission, or parole, they want you to get registered. If you are an individual submitting applications not listed um, in 8 CFR 264.1A, which they're talking about DACA and TPS people who, especially DACA, who applied but got caught in that court processes where DACA was now stopped and their cases were never adjudicated. Those people never got a receipt showing that the application was received. They want you to get registered. Now, like I said, there's been no process put forward yet. So there's nothing to do right now. We're just waiting to see what information they will give us with regards to how that should go, right? So the alien registration is a thing that it used to be law in World War II, and the Trump administration has revived it again. So now there's something new that they're looking to do, which is they want to change all those forms, like the N400, the I-130, the I-751, all those forms that we apply, we use in affirmative applications. They want to use those forms to collect biographical information, such as your contact details, your residence, relevant data of your family members, parents, siblings, children, spouse. They basically want to be able to know everything about anybody who's here so that they can find that person when they need to. And so this is not a law yet. This is not a policy yet. They're just asking for comments, what do people think? And so there's a 60-day time period within which they will accept comments and then they'll make a decision. Now, let's see, DACA renewals, still nothing has changed with DACA. They're still not accepting new applications, but they're still accepting renewals. Then the other thing I wanted to talk to you guys about is Department of Homeland Security has requested that the IRS basically assist them in finding out people who have ITIN numbers, who are working, possibly finding employers who are employing people. And as of now, the IRS hasn't, agreed to do this, but we're not sure what's going to happen. So if you have an ITIN number, chances are, if IRS is going to turn over that information, they will, nothing new. But if you don't have an ITIN number, you may want to, just keep an eye on what the news is right now before you put in an application. That's just a suggestion. So let's talk about the fact that people are scared to put forward applications. Yes, they are. They're afraid to put forward applications, and I don't blame them, because if you put forward an application and it's denied, you could be put in removal proceedings. However, if you don't put in an application and you qualify for something, you're really literally a sitting duck, right? Because the government is really trying its best to find people who are here and who are out of status. So if you have a pathway, really, it's probably the best thing for you to do to put in an application with a reputable attorney who is going to do, is going to work hard on your case, who will make sure that they put in a really strong, compelling package in the case type you're looking for. So now I want to talk about a case type that a lot of people don't know about. And I'm talking about the T visa. The T visa is for those who have been trafficked. So there are two types of trafficking. There's sex trafficking and then there's labor trafficking. So trafficking, in essence, is a form of forced servitude. Somebody taking advantage of the fact that you don't have papers to make you do certain work, right? And now, I always tell people there's a difference between somebody who is between a Department of Labor violation and trafficking. And so when we talk to our clients, we typically want to screen properly for that. But what a lot of people don't know is that if you may be able to qualify for VAWA because you're married to a U.S. citizen or green card holder who has been abusive towards you, right? And you may also be able to qualify for a T visa at the same time, because if you have a spouse who's treating you badly, forcing you to do all the cooking, all the cleaning, basically treating you like a maid, controlling you in the work that in the chores that's been done at home, and threatening you, making you afraid to leave the situation, it could be a trafficking situation instead of a case where you would file VAWA. Now, if you qualify for VAWA, which VAWA is for in the marriage situation is for spouses who are being abused by their green card holder or U.S. citizen partners. It could be physical abuse, it could be psychological abuse, emotional, financial, all the likes. They may qualify for VAWA, right? But they may also qualify for T visa, and that's what I want to talk about today, because we talk about T visas, and people think T visas only work when you are employed by a stranger. You can qualify for T visa even in a domestic situation with your spouse. And the good thing about the T visa, one of the advantages of a T visa over VAWA is a T visa does not require your abuser, and I want to use that word loosely, to be a U.S. citizen or green card holder. They don't, right? And it does not require you to be married to the person, right? VAWA requires you to be married to the person if it's a marital abuse case. So you have to be married to the U.S. citizen or to the green card holder, right? Now, in some instances, there are people that may not qualify for, who could qualify for VAWA, but they have an inadmissibility. There's something they've done in the past that makes a VAWA not a pathway for them. For instance, if they have inadmissibility such as false claims to citizenship, they have claimed to be a U.S. citizen. Maybe they filed a work, they went to they got a job, they applied and put that they were U.S. citizen. That's a false claim to citizenship. And if you've qualified for VAWA, you still could not get a green card through VAWA because you're inadmissible based on the false claims to citizenship. If you have been engaged in a sham marriage, that is also a bar to getting a green card through VAWA. So there comes T visa, which really could waive those in certain situations, right? So if you have certain inadmissibilities, a T visa may be the answer, not VAWA. So it's important that you are screened for a T visa, that you're screened for VAWA, you're screened for U visa, that you're screened for asylum, all of them. So it's important to work with attorneys who also do T visas, because we found that some of our clients that do not qualify for VAWA, they qualify for T visas. They qualify for U visas. U visas are for victims of crimes. So one of the things I like about one of the advantages of a T visa as well is that there's a broader range of people who can be derivatives. With VAWA, in a marital situation, your derivative is really your children under the age of 21. But in a T visa, it could be a sibling, could be parents. There's just a whole more people that could get their green cards through the principal applicant's filing of a T visa. So a lot of time, people come in to my office thinking that they could qualify for something else, and based on a proper screening, we are able to find the best pathway for them. And that best pathway could be a pathway that gives them a green card, gives their spouse a green card, gives their children a green card. You always want to look for the pathway that solves all your problems. All right. So what are the other instances of forced labor? Well, there are many instances of people being brought over here to the United States, sometimes on the pretext of, oh, come in, you're going to go to school, or come in, I have a job for you. And the person comes in, and that person who invites them or somebody else begins to treat them like a maid, forcing them to do work, forcing them to work long hours, controlling the manner of their work, not allowing them to look for other jobs. And this happens especially in situations of where the type of work they're doing is childcare, maybe care of an elderly family member, or even maybe they're working in construction, could be they're working in restaurants, could be they're working in what you call it, home health cares. There are many instances of trafficking, and a lot of people don't realize that they are being trafficked. Sometimes it's because in their country it's okay to treat them that way. It's okay to treat people like servants, to take their passports and keep because they're working for you. Here in the United States, that's not acceptable. So if you or somebody has been through something like that, you really want to talk to an attorney who does a lot of work with trafficking victims. My office does a lot of work with trafficking victims. We do a lot of work with VAWA clients. We do a lot of work with people who are victims of crimes. We do a lot of work with children who have been abused or abandoned or neglected by their parents and who are under the age of 21. The reason I bring up these pathways are a lot of people are not in a position to have a family member who can file for them. So lots of times they're looking for other pathways, and humanitarian pathways are really a godsend. So you really want to look and see if since you came to the United States, any of these things have happened to you, because there's no statute of limitations except for age requirements in SJIS cases and filing requirements in VAWA cases. With VAWA, you have to file within 2 years of divorce, within 2 years of the death of the abuser, and all that stuff. So it doesn't matter if this happened a long time ago. And it may not matter that you don't have physical evidence. So I think the best thing to do is to talk to a lawyer and tell your story and let them see if there's a pathway for you. Because today, in this administration, it's better for you to have a pathway. And like I said, yes, it's scary that if you're denied, you could be NTA'd. But however, if you don't do anything, you're literally just, setting yourself up for a situation where you could be put in detention and there's no way to get you out of it. At least if you have a petition, an argument could be made that there's a petition going and you should be released while your case is ongoing. So let's see. Let me answer a few questions and then, all right, let's go. Let me go up the way. So Ivan Smith says, is it true that they extended the green card holder for the next 36 months? I don't know where you got that information from, Ivan. The green card petition is, nothing has really changed with regards to that, at least not with extensions. If you're talking about the I-751, that when you file for that, they extend your green card for 48 months. That's been the rule for at least a year now. Let's see. Hello. Hi, Claire. Hello, Ehasi, Daramola, Joseph. Thank you for joining me. So Rahul says, in a VAWA case, if it's denied, can we reapply or file a motion without getting deported? Well, if you file a VAWA case and it's denied, you can always reapply if you qualify. If you can reapply if you're still married to the person, you can reapply if the case was denied within 2 years of your divorce from the person or the death of the person or whatever it is. You can. But what I'm telling you now is that the new policy is if a case is denied, they will put you in proceedings. That's what they're saying. Have they done it? We don't know, but that's what they are saying. So if that's the case, if you qualify to reapply for something else, go ahead and do that. That's what I will suggest. So Joanna says, I have not filed any documents yet. Well, Joanna, we're not sure what you qualify for. So if you would like us to assist you, give my office a call, 973-993-1900. So Keisha says, do you recommend registering or not? I think it's a trap. Well, Keisha, I'm not giving any recommendations because they haven't put out any processes yet. So when they put out a process, if it's the law, it's the law, and I don't recommend people don't follow the law. But what I'm saying is there's no process now, and that may be challenged. So let's wait and see. We're keeping our eyes open to see what is going on. Once they give us the processes, what's supposed to, how it's supposed to be done, I'll come back on here and we'll talk about it, okay? So Emmy says, I have a question. My VAWA case was approved. Can I apply for my children? Just to let you know that I included them in my VAWA case. So Emmy, congratulations. So if your children were derivatives from your VAWA case, they can come in as well. If they're here in the United States already, you can file an adjustment of status. But if they're outside the United States, they can come in through consular processing, but you do have to get your green card, and then that brings them in here, okay? So once your VAWA is approved and you get your green card approved, your children abroad can come in through that approved petition. Your children here can file an adjustment of status through your approved VAWA, but they also will have to, and they can get a work permit while they're waiting for your green card to come through, okay? But congratulations, that's great. So Lillian says, can a green card holder file a petition for their partner? Yes, you can, but this is the caveat. The green card holder is what we call is in the preference category when you're filing for your partner. So there are no visas immediately available. So if your partner is in the United States and they're out of status, they're not going to be able to adjust their status, right? So you can file, but you would have to become a U.S. citizen for them to be able to adjust their status and get their green card. Now, if you're not able to adjust your status anytime soon, then the thing to do is they may have to file a waiver, 601A waiver, for unlawful presence in the United States, and they have to depart and consular process, coming through consular process. So let me see if I can answer some questions on Instagram. All right, Instagram is really not moving that much, so I'm not seeing any questions. So on TikTok, somebody says, does I-751 get interviewed? Yes, I-751 can get interviewed. In the past administration, sometimes they wouldn't interview, but in this administration, we're expecting that most cases, if not all, will request interviews. All right, so Toby Loba said, oh gosh, Toby, sorry, I can't find. Okay, Toby says, that question went really fast. Does Trump being elected affect interviews from other countries in terms of visa granting? Toby Loba, yes, it does. And the reason is because with the Trump administration saying that they're going to reduce the staff in embassies abroad, what that means is there's going to be a backlog. What that means is that there's going to be delays in everything, getting interviews, processing paperwork, and all that. In Trump 1.0, there was a lot of delay. I mean, some of it was caused by COVID, of course, but the delay is caused by the fact that they were, a lot of things that could have been, a lot of petitions that could have been approved without an interview. They were literally interviewing everybody and everything, so what that caused was a backlog and delay. So we are expecting that there's going to be a lot of delays in the process, especially since they're putting a lot of manpower into, deportation of immigrants. So yeah, it's going to take a while. And then, they fired more judges, They're letting go of more people at DHS. So the fact that there's going to be a reduced workforce working immigration petitions just tells you that it's just going to take longer. All right, so let's see. Yes, let's see. I'm trying to. Ivan says, if the green card is about to expire, yes, you can renew it within 6 months. That's correct. Within 6 months of the expiration, Yvonne, yes, you can do that. All right. So, Johanna says you're married to a U.S. citizen. Well, congratulations. That's great. So, whether you qualify to get a green card depends on if you have making sure that you have no inadmissibilities that can prevent you from getting a green card. So some of the things that could prevent you from getting a green card when you're married to a U.S. citizen is if you've been involved in a prior sham marriage, if you have a false claims to citizenship, if you have certain inadmissibilities. So you do want to talk to an attorney. And if you have no inadmissibilities and you came in inspected or paroled in, then you stand a good chance of getting your green card approved. Okay. All right. Let's go to Instagram. See if there's any questions. So Michelius Salmon says, can a U.S. citizen child file for a step parent if the marriage happened when the child was 21 years of age? So Michelia, that's a really great question. And the answer to that is no. For a U.S. citizen child to file for a step parent, that relationship, the step relationship must have happened before the child turned 18. So if the step relationship, the marriage between the parents that caused the step relationship happened when the child was 21, that child, under immigration terminology, is not a stepchild that can file for you. Okay. So Emmy says, can I give you a call to assist me in filing for my children? Of course, Emmy. Give us a call, 973-993-1900. All right. So I'm looking for more immigration questions. So Osh Media says, if someone was arrested but the case was dismissed and she later got her 2 years conditional card, is she safe to travel currently in this current political climate? Okay, Osh. You know what? This is what we're hearing, that people who have a 2-year conditional green card, if they travel and their case is denied before they come back in, they won't be allowed back in. And if you have an arrest, this is what I always ask clients who have a prior arrest. Even if the case was dismissed, what were the terms of the dismissal? Did you take a plea and admit to anything? Or was the case dismissed without a plea, dismissed in its entirety? It makes a difference if you took a plea and the case was dismissed, because if you pled to something that makes you inadmissible, that could be a problem later on, in your immigration future. So I would say it's important for you to talk to an attorney and make sure that that this is not going to be a problem. I don't give legal advice on live because I don't know your story. But if you would like for us to assist you, give us a call, 973-993-1900. All right, guys, I have a meeting at 3:15, but thank you for joining me. And I know I missed last week and the week before because honestly, we're working, trying to put things in place. But there's just a lot of information that I know I need to share with you guys. So I'm promising you that I will do that. Okay. Emmy, I'm not in DC, I'm in New Jersey, but we serve clients in all 50 states. So give us a call. We can assist you. Okay. Take care. Bye-bye.